start in about 90 seconds. Good morning, everyone. My name is Margie Russell, and I'm the Executive Director of NYARM. Welcome to our monthly meeting here today. I'm going to start with a few announcements before we get into the topics and the speakers. And the first announcement is from the Department of Sanitation. Eve, if you would like to join us.
Thanks very much, Margie. I'm very happy to be here. Good morning, everyone. My name is Eve Martinez. I am with the Department of Sanitation in the Bureau of Waste Prevention, Reuse, and Recycling, which is the recycling unit, as we call it when we are out of breath. And I'm here to just talk briefly about 3 programs that we have that are aimed specifically for apartment buildings. And I've left brochures and pamphlets on these programs on your tables to take with you when you leave. And these programs are designed to reduce and eliminate the waste that is coming out of your apartment buildings, and to save you money, and to save your resources, and to redirect the energies of your building staff from slogging around in the basement, digging garbage out of your recyclables into more productive activities as to improving your building, improving the quality of life for your residents, and more productive things like that. The first is the Apartment Building Recycling Initiative. And that is the program, it's a support program for your apartment building. You register the building in the program, and we offer training sessions to teach you best practices in how to set up your internal recycling operations, how to set up a very effective recycling area, how to communicate with residents who don't want to be communicated with, how to keep up with legislative updates, such as former Mayor Bloomberg's expansion of the plastics component of the curbside recycling program. And it's a way for you to keep in touch with us on an ongoing basis. We can train all of your building staff, we can train your residents, or we can give trainings to your residents. And so that's a very effective way of doing your due diligence, of doing everything you possibly can as a building manager to comply with New York City's laws, recycling laws. The second program, which is extremely relevant right now, is eCycle NYC, which is an in-building collection program for collecting electronics. And the reason this is very relevant is because there's a state law that's going into effect in 2015 where it's going to be illegal for residents to put any electronics in the waste. And so there are other options for residents to safely dispose of their electronics, mainly dropping off their electronics at retailers or sending them back to the manufacturers. But this is a program where we work with a state licensed vendor, and we put a cage, is what we call it, in your building, and the residents bring their unwanted or broken electronics to your building staff, and they put it in this locked cage. And when the cage is 75% full, you call the vendor, and they come and they take it away. So that's literally tons of material that, number one, is illegal to be put in the waste as of 2015, and also tons of material that your building staff won't have to drag out to the curb. The third program is Refashion NYC, which is targeting textiles, gently used clothing, linens, hats, belts, shoes, etc. And in this program. We're partnering with a nonprofit, Housing Works. And it's very similar to e-cycling. We put a bin in your building, usually next to the laundry room. But this time the residents are free to go down anytime they want and dump their unwanted, it doesn't matter if it's ripped, whatever, as long as it's clean, in the bin. There are tax receipts attached right to the bin, so as long as they're willing to take a tax write-off of $250 or less, they can rip a receipt off and give it to their accountant. And again, when the bin is about 75% full, your bin monitor, which is usually your super, calls Housing Works, and they come and they empty it. So again, it's going to be tons, because we're beginning to get the numbers. It's tons of material that your building staff will not have to carry out to the curb. And it's not clogging up your chute, and it's not burning out your compactor's motors, and it's extremely popular with your residents, and it's making your building more efficient, and you're reducing the waste, and you're helping us, and you're helping the environment, and it's all good. It's a win-win-win situation. And so there are brochures on the table, and I'm going to be around if you have questions, and I hope to see you all in upcoming training programs for ABRI, because I'm the program manager for the Apartment Building Recycling Initiative. Thank you very much.
Okay, well, completely keying off that, in our Help Our Veterans effort, we have Recycle Your Clothing and Household Goods.
Thank you. Good morning. My name is Deborah Menick. I run the Clothing and Household Goods Recycling Program for the veterans in the city. We collect around 90 tons or more a month that we move out of the waste stream, following the concept of reducing waste, reducing the tax burden on everyone in the city, and keeping the city in a more environmentally friendly way. How do we do that? We come to your building. All you do is you call us when either the super, the building manager, or a resident would like to donate items, whether they're clothing, household goods, plates, cups, kids stuff, golf clubs, shoes, electronics, whatever they are wanting to give. We will then come. We're there between 3 and 5 days. If, for instance, you need something in 24 hours cleared out, we have trucks in the city every single day. As I've said, we move around 90 to 100 tons a month, so we're rather actively in your area. You can always give me a call and I can help you get it out within that day if need be, but in general we ask you to log on or call the 888 number and schedule a pickup. The beauty of our system is that what we pick up, we don't put it in bins, we don't throw it in the back of a truck. We handle it like a white glove concierge pickup service. We have 17 large thrift stores around the area. And when I say thrift stores and large, I mean 30,000 square foot buildings that used to be Kmart's, look like Targets. We want the people when they walk in to feel like they're going into a Nordstrom's and they're not buying secondhand clothing. So you will have the men's wear by size, by color, with the men's shoes all in that same area. We feel the best way to repurpose and reuse and not really stress the carbon footprint is to take a shirt from you and give it to you and hand it down to you. And with that, all the proceeds go to the veterans. We feel that handling the items in that manner gives us the best bang for the buck. We handle all types of different local veterans programs. There's around 250,000 veterans in the 5 boroughs registered at the VA right now. Maybe that's a third of who all lives here. This year alone, we're expecting another 44,000 veterans to come back into the 5 boroughs. So those donations are more needed than ever. Again, we leave the tax receipts. We're there on call to pick it up. It's as simple as just dialing the 888 number or logging on and getting a pickup. So we have information as well in the back that we will distribute, and we'll be here all day to help you learn more about our programs. Thank you, Margie.
And for example, both these ladies have spoken at the various superintendent organizations. So some of this information you'll be hearing up from the superintendent saying, why don't we do this, why don't we do that? And so it's important that all of us understand at each level so we can make it happen, because they really are very good programs. Now, one of the most incredibly effective programs that I have seen in a long time is the CERT training, the Community Emergency Response Training. And there's various locations around the city, various different districts, and the Battery Park City CERT is the main one. Now, how this works is you don't have to live or work or have an interest in the district that a particular CERT serves. You just have an interest in either the way a particular CERT team handles themselves, or the fact that Battery Park City is where all the emphasis is, so you get more of the outside FEMA training and more national attention, and it's a very exciting place and very effective. So most of the resident managers and the staff that have taken the training have taken it through the Battery Park City CERT, which is different from the training, slightly different from 32BJ, because I'm not sure if they're attached to the Battery Park City CERT. They're doing a New York City CERT as opposed to a FEMA CERT. Slight difference, same training, but a little different emphasis. But 10 years ago, Ephraim Lopez, resident manager, walked into my office with a couple of other gentlemen and said, we're doing the CERT training, you want to get involved? And I just, and I didn't. And I just watched them progress over the years, and it has really taken off. And Ephraim's going to give you a couple of minutes on what that training is, or some of his insight into it. And so recently, they had a drill. So they've been doing trainings, but they really haven't had a real live drill, you know, with the fake blood and the people screaming and the dark and the dogs and the bikes and all this kind of stuff. So they had that back in January, and we were invited to report on it in any way that we could. So we filmed it. And so, as you hopefully know now, everything we do is on YouTube. And so this drill is up there on YouTube, and you can watch how your staff, your resident managers, are going through these drills. So hopefully, if they never have to use that training, they will definitely use it every day in your building. Because if you can handle yourself under those conditions, and you will see those conditions, if they can handle themselves, they can certainly handle themselves in the normal ebb and flow of the problems that happen in the building each day. So I just would like you to hear from Ephraim Lopez, who is the resident manager at the OM. It's an apartment building on the far west side at Levine Builders. It's yours.
Good morning. Good morning. You guys are really excited. Okay. My name is Efren. I'm the resident manager at the OM. I've been in the industry for a little over 30 years. And it's been exciting. It's been ups and downs that you learn over the years, and some of the stuff you kind of address when you are there. Unfortunately, some of the things that happen in the industry, let it be fire, explosion, or whatever the case may be, sometimes you're not ready for it, and you kind of just use the best you can in judgment to address issues. But I was lucky enough 10 years ago to be introduced to the CERT organization, and I've always been very conscious, very into education and doing the best I can to educate myself and provide the right information for my residents, for the owners, for the developers, et cetera, et cetera, et cetera, et cetera. So when I was introduced to CERT, I was really blown away to be able to have an organization that had a passion like I had. And I took advantage of it, and I've continued to take advantage of the organization. As Margie just mentioned, we just had a drill like a month, 2 months ago, and it was great to be able to take a room and make believe put the scenery of an explosion that took place, and we had dogs, and we had smoke, and we had lights, and we had the whole works. And Hank, which is one of the leaders for the CERT organization, did a great job, But it goes more than that, and they have a whole education division, or part of their organization is to educate. And I've been a part of it several times over, and where you learn how to address a fire. We've been to the New York Fire Department Academy, where you actually go to where the real firemen have their academy, and they have their sessions, how they get trained. Well, we've been there to be able to address how do you address people when they're burnt, when they've broken arms, when whatever the case may be. So I find it just a great tool to be able to have the board members and developers and property managers, get your resident managers involved and your property managers to be part of CERT, to check it out and see that, wow, I mean, we have, nowadays we have a whole list of things to do in properties, of what to do and how to do it. And the book is great, and the paper's great, and all education and videos, all that is great information, but it's essential when you actually are there and you go to one of the drills and you actually hear and see how it's actually done, or at least have an idea of how to address an individual that's, her arm has been cut off, or whatever the case may be. I say blessed to have enough education to deal with the Sandy situation. I'm located at 30th Street on 11th Avenue, 312 11th Avenue for Levine Builders, like I mentioned before. And it blew me away how everything just fell in place. We didn't have no light, we didn't have anything. So how do you address everything from, how do you communicate to the residents? And make them feel comfortable and make them feel like there's someone here that's in control, management is here, the resident manager is in place, this is what we need. And one of the things is not waiting for it to happen, for them to then say, I need to be educated. Or I need to, the basic things like having water and a generator, and things like that, little things like that. And I found it so, it blew me away when I was in 29th Street, and the water was coming up, coming up from 11th Avenue, and I'm just standing there, my staff is there about 3, 4 o'clock in the morning, and everything is under control. I had gone to Pennsylvania to pick up 2 generators, come back, have my staff throw troubleshooting lights. We finally got there with food light, everything calmed down. Well, we sat down, I think 12:30, 4 in the morning, we're outside, we're looking, and I'm seeing the water coming up, from 22nd Street, and it's coming, I think it went up to 28th. I was hitting 29th Street. I'm saying, good Lord, now, what do we do now? So it blew me away to be able to see that. But anyway, the point is that it was great for me, my staff, for management, for the developer, to feel comfortable and know that someone at the front, till we get there, and all the agencies come and do their thing. But it was great to have a resident manager with their staff trained, in place, taking care of the property, taking care of the people, taking care of the kids, taking care of the dogs, and all the other but sometimes it sounds like little, all the details that we are responsible for. So I welcome you to this church. You could call Hank, you could call me. I got my card if you want some information, and come check it out. I think you'll enjoy it. All right? Thank you.
Thank you. Louis? And as you can see, there's so many different places for your staff to get education. And what's going to make your day and what's going to make your year and your career is how well your staff responds to the problems that come up. And so that's why it's important not only to be exposed to it, but to actually do it, to get them out there. The union has the largest training that I know of, so take advantage of it. But your staff may not be in the union, your staff may not have the time available. Even here, the Mechanics Institute, classes every night in exactly what you want to learn. The CERT training, the different resident manager clubs where they have a peer system, which they need so much. Okay, so at this point, I would like to introduce 2 partners, Mark Hankin and Jeffrey Mazel with Hankin and Mazel. And the first topic is the epidemic, right? Yeah. And so we've been hearing an awful lot about mold and MRSA. This is a different kind of epidemic, and I'm going to let you handle that. Okay.
Good morning, everybody. Good morning. Good morning. Okay. My name is Mark Hankin, and my partner Jeffrey Mazel. We have a firm, it's called Hankin and Mazel. We have offices in Manhattan and in Long Island. We concentrate our practice on co-ops and condominiums. We actually represent the boards of directors, the boards of managers, And by virtue of that, we represent the managers of each one of the properties that we represent throughout the city of New York. First of all, I want to thank Margie for having us here today. The topic that she was interested in discussing was discrimination. Look, it's a huge topic. I'm a litigator. I do litigation in the firm. I have litigated in every form you could possibly think of with respect to cases of discrimination, both in federal court, in state court, in the New York City Commission on Human Rights, in the New York State Commission on Human Rights, the Fair Housing Administration, the EEOC, the Equal Employment Opportunity Commission, as well as in HUD, Housing and Urban Development. Why do I mention all of these federal agencies and all these state agencies? Just to give you an idea of how many governmental entities there are representing people regarding discrimination. If the number of governmental agencies are so significant, you can only imagine the number of claims that are made on a yearly basis. It's an epidemic. That's why we called it the epidemic of discrimination. When I started my practice approximately 25 years ago, there weren't that many, and most of them had to deal with shareholders who were applying to a co-op or to a condominium and were denied residency, allegedly based upon some type of discrimination. Those were the big ones. In fact, those claims have reduced to practically nothing in the most recent years. And if you're aware of all the bills that the legislature's been trying to pass, both the City Council and the State of New York, the Shareholders' Bill of Rights kind of thing, you'll notice that those bills never passed because the number of discrimination claims has reduced. On the other hand, we have an epidemic in employment discrimination. This seems to be the big one. I seem to have multiple cases. My firm is handling many of them. I litigate them all the time, and they just seem to be coming up constantly. If you're a building manager, and even if you're a vendor, I met a lot of you here this morning before we started, you need to be able to handle an employment discrimination claim. You need to know up front what not to say, what to say, how to handle a firing, how to handle allegations of sexual harassment. These are things that are very difficult for employers. I do it this way. I say, when you're considering an employee, to fire that employee, you have to stop. Stop and think. Those are the two words, stop and think. Because everything you do from the moment that you fire that employee or lay that employee off, it doesn't have to be a firing, because they have a law, it's called constructive firing, okay? So even though you didn't say you're fired, if you let them go, but you did it because of some type of discriminatory context, you're still responsible. So you need to stop, you need to think about the ramifications of firing an employee. I'm going to start with that one. I only have 15 minutes, and then I'm going to go through a bunch of others, and I'll give you some interesting stories because I'm a war horse, and I've tried a lot of these cases, and so I can give you some interesting ones to think about. But for now, focusing on the employment issues. Okay, you've got an employee, you don't like the way he's performing, you're about to fire him. I don't care if you're a property manager, I don't care if they work for the property, the board of directors directly, a super, I don't care if he's a porter, I don't care who it is. If you're a vendor, you've got employees, okay? You've got to stop, you got to think. You're about to fire him, okay? How old is he? Is he 40 years or greater? Is he 55 or older? There are certain thresholds that the federal government has, and you've got to be careful. What's your next step? I've got a 55-year-old, I'm about to fire him because he's not performing well. Well, that's a very good, legitimate business reason for having an employee terminated. However, that employee is of an age where there is an inference that this could be age discrimination, one of the prongs of the federal statutes, the state statutes, and the city statutes. So the next thing you need to consider is how you're going to fill that spot. Or maybe you know what the statistics in your employment are. If you do, then it's pretty easy. If you're in a firm of, let's say, 100 employees, which is pretty easy, you take a look at your numbers and you'll know how many people do I employ who are 55 or older, how many people do I employ who are 40 or under, how many people do I employ who are 70 and above, okay? If you're going to replace a 55-year-old employee with a 20-year-old, he's going to claim age discrimination. I promise you, okay? It happens all the time. They're saying that you're replacing him with a younger individual because you felt that because of his age, he was unable to handle that particular job. You have to be smart in the manner in which you replace employees and stop and think about the consequences of a firing of an individual. There are employees that will be working with you who will claim that you're doing certain things to them that are prohibited under federal and state law. Sexual discrimination in the workplace. They have a new one, pregnancy discrimination. There's a law that just came out, it's effective January 30th of 2014, where pregnant women must be given notice, actually has to be posted in the employer's office, of their rights to a reasonable accommodation. Very important word, reasonable accommodation. It spans most of the discrimination statutes, both in the federal government and the state of New York. You must reasonably accommodate a pregnant woman during her pregnancy in your office, okay? And once she is let go under the Family Leave Act, okay, you have an obligation, you have a right to fill the spot, but you have an obligation to take her back if she wants her job back after she leaves. So be careful about how you treat a woman who's pregnant in your office. She has a right to bring a claim for discrimination. Sexual discrimination, another big one in the employment field. Someone accuses another employee of doing something improper, either in your site or outside your site. Remember, you're the big bad employer, okay? It's your obligation. You're the one that has to make that determination. You get a complaint at any time of sexual discrimination, you're obligated to take it as seriously as you possibly can. You're obligated to investigate it, and you're obligated to come to a conclusion, one way or another. That conclusion is important to how this case, if one is ever brought by that employee, will play out. These are the do's and the don'ts I'm trying to give you in a brief, very brief manner of how to handle employee situations. I want to go on to another topic, which is building-wide. Since most of you, I think, are property managers or vendors, okay, I have a lot of cases regarding the actual structural nature of buildings, okay? And for instance, I had one case where a completely blind woman lived in a cooperative, okay, in an apartment, and she was unable to get access to the building. She couldn't communicate for people coming to the front door with her. The access problem had to do with the ramp that was leading from the interior of the building to the garage. Now, woman moves into a building, she's blind, and she decides that she wants to get access to her handicapped spot, okay, with someone, okay. She's entitled to that. She's entitled to what's called, again, a reasonable accommodation. This is the big cue here, okay? And the question then becomes, it turns out that that ramp was not appropriately pitched, and the question then became, how do we accommodate this woman, and how do we fix that ramp? What's a reasonable accommodation? If I have to spend $2 million to resurface that ramp, that's not reasonable, okay? And most of the time, most agencies will agree with you, and you won't have to make that change. You may have to find another route for her, but you're not going to create a $2 million deficit for a building because of one person's need for a ramp. The other thing she wanted, she would like to be able to use the intercom system. So she wanted the intercom system, that's a standard intercom system at the front door of a building. She wanted it all made in Braille. And the question then became, what was the cost? who would it hurt, and could the co-op or the employer or the owner do it and make a reasonable accommodation. In that case, they in fact found the company, they converted the intercom system to a Braille and regular manual system, and she got her Braille on that intercom, because you do have to make, it was not a costly measure. I think it cost in total $8,000, but the bottom line is the same issue, reasonable accommodation. So we've got ramps for disabled people, we've got to make reasonable accommodations for blind people, okay? There are many disabilities which require that we provide special types of situations and needs and convert our building to make them what they call ADA friendly. Those things you have to be very concerned about, and it's important that at the outset, when you get the request, Mr. Hankin, I'm in a wheelchair now. I live in a 2-family garden apartment. I can't get into my house. I'm going to instruct the co-op to build a ramp. They're going to put a ramp in front of that 2-family garden apartment, because there's no other way that person's going to get into that apartment. That's a reasonable accommodation. If you don't do it, I'll tell you what the consequences are. They file a claim. They could file it both in federal, they could file it in state, and the city has their own human rights department also. You will wind up getting a claim. These claims get filtered through a system where you get to put in an answer and tell them why you didn't want to give this accommodation. You'll go to what's called an informal hearing with an investigator who investigates the whole situation, both from your side and from the side of the complainant. That investigator will determine whether or not there was some type of probable cause to believe that you committed some discrimination. And if they do make that determination, then you're going to go to what's called a fair hearing. And you're going to be in front of an administrative law judge, and you're going to produce witnesses, and they're going to produce witnesses, and the end result will be a decision by an administrative law judge as to whether or not discrimination occurred in any particular instance. There's also something called retaliation. That's when you knew it was discriminatory and you purposely and intentionally decided to act in a specific manner to make sure that they could never get the accommodation. Okay? In all of those cases, in federal court, they're entitled to their legal fees if they prevail, they're entitled to money damages if they prevail, and they're entitled to corrective action where you are compelled to make that ramp, or you are compelled to put that Braille system in. Whatever it may be, that's what the possible results are. I, in fact, practice a lot of this type of law. I've been in many of these situations. Most of the time, when it's handled properly by a proper lawyer who has the background to do these kind of cases, there will never be, or most of the time there won't be, a probable cause finding, and the complaint will be dismissed. It's when you go to the hearing that you don't know what the result could possibly be. Once probable cause is found, you're going to a hearing, witnesses testify. It's really based upon how the administrative law judge sees the testimony, weighs the value of the evidence, and the witnesses brought, and then you find out what his decision is. You also have a right to appeal the decision of the administrative law judge, as does the complainant if his complaint is dismissed. This is what you're in store of in the world of discrimination, but the idea is, and I'll say it again, stop and think. Every action has to have a reaction. If you're thinking about terminating an employee, stop and think. If you're thinking about not giving a reasonable accommodation to a person, stop and think about the consequences. There's a way that you could avoid litigation. There's a way that you could avoid a substantial damages. There's a way that you could avoid having to take corrective action if you just stop and think. I'll give you some interesting cases. You probably hear all the time about the fact that we have this pet law in the city of New York, and if you don't get rid of your pet, if the owner doesn't do something within 90 days, the pet gets to stay in the house or in the apartment. There's also many, many people now who are claiming that they need an emotional distress animal, ESA, emotional distress animal. Yeah, and it happens often, and they claim that, in fact, I need this dog, or I need this bird, or I need this whatever to help me through life. My doctor says that if I have this pet, if I have this animal, I can get through my problems, which could be emotional, which could be psychological, which could be physical. There's a multiplicity of these types of cases. Recently, I had a case, and I'm not going to mention what county, but the woman claimed that she brought a pig into her apartment. Pig, okay. And she claims she needs that pig for her and her children's emotional distress. She's claiming that her brother had recently passed away. She's had emotional feelings about it, that the children, their uncle, has had emotional feelings about it, and that they need to do something. And that what they did was they took in a pig, and they'd like to keep that pig in the apartment. Well, naturally, the cooperative, the owner, wasn't very happy about that, nor were the residents, that a pig had been brought into the apartment. So we, as the attorneys, we checked the law, and it turns out that there's a law in the city of New York. You're not allowed to have a pig in your apartment. That is prohibited by the New York City law. And it specifically says that that's a farm animal, and it needs to be placed outside the limits of the city of New York. So we notified the city of New York of the issue, and we asked them to take action. Okay. Their action was to issue an order telling the unit owner that you've got to remove this pig from the apartment. Housing and Urban Development is now involved in the case, and they feel, just to show you that there are these agencies out there that are, no matter what, discrimination claim is a discrimination claim. They feel that perhaps a pig could be an emotional distress animal, and they don't see why she shouldn't be able to keep that pig in her apartment. And they're fighting for it. This is a continuous battle that's going on. I'm going to take questions after. Okay. This case is pending. It's pending both in state court, and it's also pending in HUD under their administrative guidelines. No decisions have been made yet, but I just want to show you how far all of this can go in a discriminatory context, and how many people can claim a lot of different issues, both with property, both with livelihood, both with employee status. And you need to stop, and you need to think. The co-op had every right in this case to let her know that she had no right to keep a pig in her apartment because the New York City law says you're not allowed to. Okay. But HUD's saying, and by the way, federal statutes sometimes preempt local and state statutes, that perhaps because it's an emotional distress animal, and perhaps because the co-op should give her a reasonable accommodation, that she should be allowed to have a pig. That's where we stand. I thought it was an interesting case that I bring to your opinion here. I just want to go down the list so that you guys know all the potential claims that I go through and that you could hear about. The easy ones are the age discrimination and the race, color, and the sexual orientation claims. The other ones that are not widely known, but in fact occur, and that you should be aware of are things like arrest records and conviction records. If someone applies for a job with you, you really are not allowed to discriminate based upon an arrest record. You can discriminate based upon a conviction record, but it's based upon the quality or the type of the conviction itself. And there are human rights laws which prohibit discrimination based upon the firing and the hiring based upon criminal records. Disability, we spoke about, it could be physical, it could be mental. There's a domestic violence discrimination that occurs both in homes and in buildings itself. family status discrimination. Clearly, in the world we live in today, anyone who attempted to prevent someone, two couples of the same sex from not residing in a housing unit would be foolish. There is harassment of domestic workers, which you hear about on the radio and in TV all the time. And it occurs a lot these days, and we get a lot of claims with respect to that. You cannot discriminate based upon military status, national origin, and basically that seems to be the whole list. My point being, there's an epidemic, and I have a lot of these claims, and a lot of these claims don't make the threshold and are not sustained with probable cause, but a lot of them are. And there's a way you as employers, as managers, as vendors who are overseeing employees can prevent employment discrimination from happening both in the beginning and at the end. All you have to do is you have to stop and think about what the ramifications are of firing somebody, of hiring somebody, the ramifications of listening to an employee telling you something's happening in your firm, in your company, that may be a negative to both the company and affect the human rights of another person. So that's my story. Thank you for having me.
On ramifications of board communications with each other and third parties, including their attorneys.
Yes, hi. My name is Jeffrey Mazel. Thank you, Margie, for inviting us. Before I speak about my topic, I see we have veterans here. Mark and I go to a lot of board meetings, as you can imagine, and most of them are mundane, same issues over and over. I was at a meeting last night with an exceptional story that I thought I'd relate, and it related to veterans, which made me think about it. We have the privilege of representing Deepdale Gardens, which is in Little Neck. It's a large garden apartment complex. They celebrated their 60th anniversary a few months ago, and Congressman Steve Israel was there. One of the shareholders came up to Congressman Israel and said, "My father was a veteran of World War II. He's 92 years old. He never got his medals." So Congressman Israel followed up and went through whatever veteran affairs he had to follow up with. And in fact, the man was entitled to medals, and he had the medals produced. And we had a ceremony for the man last week where he was presented with his medals and a flag in a box that flew over the Capitol. And it was one of the most touching things I've ever seen. And it was a great moment for the co-op and for the man. And even more exceptional, his 94-year-old brother was there. So it was a great story, and I just thought I'd relay it. Back to the more mundane topic of board communications, especially for you managers out there. There's a lot of information that goes back and forth with boards of directors, and there's a way to manage it, there's a way to think about it that hopefully after you hear what I have to say, maybe you'll think about it in a little different way, maybe be a little more careful, and hopefully someday, somehow, somewhere, prevent maybe a lawsuit down the line, or maybe just misinformation, or maybe embarrassment of either yourself in a professional capacity or the board members. First thing to understand is, what is a board of directors? A board of directors is a statutory appointment through a corporation. So the entity as a whole is made up of individuals. So the board as a whole can communicate through various means. And of course, the first means they communicate through is through their minutes. Board minutes are extremely critical. You need board minutes because any person who's purchasing in a co-op is going to want to see the proceedings of the board of directors, and they're going to want to see minutes. So there has to be minutes. If a board of directors has no minutes, and I'm sure Mark and I have had this experience, and a client comes to us who wants a purchase in that building, the first thing I would say is, this is a co-op that's not being run like a co-op because they don't have board meetings. What's encompassed in the minutes? The most important thing that needs to be in minutes is first, you obviously, basic stuff, time and date of meeting and who's present, and just a declaration that a quorum is present. Once a quorum is present, and a quorum is a majority of the board of directors, you can have an official meeting. How does a board of directors do anything? How do they act? They act by voting, and you need a majority, and again, different votes are different, but you need a majority of the persons or the directors present to pass something, to act, to vote on a contract, to vote to hire somebody, to vote to terminate somebody, to do anything requires a board vote. The minutes must clearly reflect that a motion was made, and who made the motion. A motion was seconded by whoever it would be, and a discussion was held, and a vote was taken, whether it passed or didn't pass. This is important because someday, again, God forbid, there is somebody either that wants to either maybe bring a lawsuit, or there is a lawsuit against the corporation, or somebody wants a purchase in the corporation. Everybody can see, the world can see, that the minutes reflect exactly what happened. That being said, there are duties of confidentiality that the board members have. Okay, you can't, or let me put it this way, a board member is not supposed to leave the meeting and tell everybody all the gossip about the meeting. They have a duty of confidentiality. Unfortunately, the enforcement of that is very difficult because to get rid of a board member generally requires a shareholder vote to remove a board member. What we usually recommend is when new board members come in, we do have a code of conduct that we would have them sign and also explain, and again, property managers can explain this too, that you have a duty, a fiduciary duty of confidentiality. What happens in the boardroom stays in the boardroom, not because there's a cloak of secrecy. I believe in transparency, but to manage the corporate business, everything can't be published every minute of the day. If we're thinking about doing a project and the whole corporation, every shareholder knows about it before we even decided to do it, I can't, as a board member, operate with impartiality and do what's best for the corporation because 10 noisy shareholders are bombarding me with emails or phone calls or what have you. So the board the board members have a duty to disclose what's happening, but not on a minute-by-minute basis, but rather through board proceedings. And then the minutes can be disseminated or can be available for review. Let me just say that the minutes are not disseminated. The minutes are kept by the property manager or in the corporate offices. The question becomes, who can see the minutes? Well, statutorily, the only minutes that shareholders are allowed to review are annual meetings. My advice usually is, as far as board minutes, I let them, I recommend they're available because, again, for resales, just as a matter of transparency, they should be made available because it helps the corporation. What Mark and I usually recommend, though, is have your minutes and then have what we call executive minutes. And executive minutes are those items that require some sort of privacy issues. You're talking about a potential discrimination case. You're talking about existing litigation. You're talking about shareholder issues, privacy issues that are not for public dissemination at this point. What I usually would have a board do is put those in executive minutes, not generally reviewed for resale purposes. In the event that we have to produce them, the board has to produce them, we do, you would have to show them either in a court setting or what have you. I'll tell you a funny story. We took over a building and they were all about transparency. That's wonderful. They actually published their minutes in their newsletter. There's a big co-op that we represented. And I look at it, and we were talking about litigation. And they published what they felt they should pay on a lawsuit that's outstanding. And we pulled the board in and said, this never happens again. Make sure you have executive minutes. And what this board does now is they take a synopsis of the minutes. The property manager goes through it carefully, I go through it carefully, and then we publish, because we want everybody to know that we're thinking of renovating the lobby, we're thinking of redoing the elevator, we have local law 11, there's going to be a scaffold outside, and people are entitled to this information, and quite frankly, transparency helps the boards, it helps you as managers, because people know what's going on, because there's always a few in the building that are afraid, you know, something's happening, we don't know what's happening, so it's all terrible, it's all, you know, there's some ill-gotten gains are being had. So that's a way of preventing that. Websites and newsletters are now obviously, you know, fairly standard for co-ops to have some form of a website or a newsletter on the website or a separate newsletter. We always tell our boards what goes in a newsletter should be approved by the whole board, because that's the communication of the board of directors. And the board of directors is a majority of the board members. And what they decide goes into a newsletter, assuming it passes, you know, a legal review or management review, is what should be disseminated, not the opinion of one board member. That's not a communication by the board of directors. That's one person's opinion. And again, the board members are fiduciaries. So you serve the corporation as a whole, not your individual standpoint. So if a board member doesn't like what you're saying, you can vote against it. At that point, a good board member will not push it any further. But again, be careful. Websites, what I always tell my clients is, if it's a publicly accessed website, it obviously should give a positive spin on your corporation, because you're talking about property values. Your website is not going to be it's not a blog. I find the blogs are extremely destructive, and you know, it's usually the same group of shareholders who are not happy with the board, not happy with various things, and can hurt everybody in the building by expressing their personal views of what's wrong. But the website under the board control, the first few pages or connections should be, you know, maybe pictures, description of amenities, etc., etc. And then usually through a login, you'll have access to certain documents, whether it be a alteration agreement, sublet application, proprietary lease, pro forma proprietary lease, and bylaws. That should usually be through a login through your shareholders, because that's, again, corporate information, private information that you want to make accessible at a certain level, but it's not for me to go on or any third party to go on and just look at without some sort of controls. Emails. And emails, to me, E in emails represents the word enemy. Okay, emails it's incessant at this point. I see you smiling. I mean, you could say good morning and get 1,000 emails back from certain boards. It's relentless. My recommendation, and I say this all the time, is keep your emails limited. Keep your opinions and your emails to yourself, because, and Mark and I have seen it too many times where somebody says something, I don't think we should put a ramp in, the guy can walk, I saw him walking yesterday. Not good. Doesn't help your case. Doesn't help anybody. Doesn't matter what you're thinking at that particular moment. You're on a board of directors. Again, what I always say is, if it's regarding any sort of potential litigation, any sort of potential claim, no emails. Don't email me. And if you email me, please stop the emails. These can be subpoenaed. Your conversation becomes a permanent record. And that's a problem, because conversations generally are not meant to be permanent records. In the boardroom, your conversations are not permanent records, because the only thing that comes out of the board meeting is the minutes. And again, the minutes are, again, as I said before, should have motions, approved, not approved, and maybe some discussion, but it's not a transcript of what happened. Email is a transcript of your conversations. So I'm a very big advocate of, let's do a conference call, when is everybody available? And again, discourage the email back and forth, because, and I'm sure, again, you've seen it too many times where people say things that don't help the corporation. It may be a person's opinion, It's nice, but it's not the proper forum to express that opinion. If you're at a meeting and you have an opinion, you know, again, we're here to discuss, that's fine. The email does an accomplishment. The email, again, establishes a permanent record of what was said and can lead to embarrassment later. That person's a jerk, I don't believe him. Again, it's all kind, you've seen it all, I'm sure. And I strongly discourage it, and we've seen too many times, especially lately, emails get subpoenaed, and they're subject to subpoena in a lawsuit, and people say things maybe in the heat of the moment, or maybe not, but they don't help anybody. All right, at this point, I want to thank Margie for having us, and enjoy your lunch, or whatever you're doing next.
You're ending this.
I'm ending this, yeah, it's hard to follow pig stories, I just want to let you know. I hope you will.
Thank you very much, Jeffrey.